All right, guys, let's go back. Let's start back against the chapter 7 for contracts or ending the contracts, basically. Excuse me. So this particular chapter, again, things in terms of the slide is owned by McGraw-Hill in terms of copyrights, and the slide is prepared John Piccolo in Niagara College. Okay, let's start. There's about six objective for this one. Number one, understanding the obligation owed for each party during the life of the performance of a contract. Number two, know what the problem arises in performing a contract. And then examining affect the problems in performance with have in our contract. Number three. Number four, describe the ways to a party that can exist of a contract or with or without consequences. Number five, recognize the difference between a breach of warranty and a breach condition in a contract. Number six, understanding the remedy that can be applied to a breach of contract. Okay? That's what the performance of contract. Performance of contract is the completion of a party obligations under a contract to the reasonable dissatisfaction of the party. Each party must know the contract that has ended. Discharge of contract is the release of each party from further obligations. Okay? They are performance of the breach of the contract. What is the breach? Breach means the failure of a party to perform their obligations to the other parties at a reasonable satisfactions. Okay? It can end a contract. What are the five ways to end a contract? By performance, by agreements, by frustrations, by operation of the law, by the breach of the contract. Okay, that's the key part. All right, let's look at the next one. Performance. All one by one with the division. All foremost, the obligation must under contract have been met to the reasonable satisfaction of each party. A minor breach means the contract has not ended. A major breach means the contract has ended. The agreement. The parties must have agreed either in the contract itself or in a mutual agreement that the contract has finished. There are three types of agreements. Waiver of an agreement, a new agreement substitute for the original one. A contract may contain clauses to discharge the contract. It has conditions, precedents, a condition subsequent, or options to terminate. Frustration. Should the no-fault of the parties, the contract has become impossible or unnecessary to perform. Must not have been known at the time of contract formations. Cannot be caused by one of the parties either deliberately or through negligence. Breach of contract. There has been a failure by one party to perform an essential term of the contract to make it necessary for the other party to terminate the contract and move on. A contract must be treated as ended. The innocent party is entitled to remedy regardless the type of the breach. What are the performance? Substantial performance means occur when all except for a trivial part of the contract obligations have been performed. The other party must still perform the obligation under the contract. What are the tender performance? It is an attempt by one party to a contract to perform its obligation under the contract. It indicates the willingness, readiness, and ability to complete the contract. It allows you to sue the other party for compensation for failing to perform the contract at all. The key part here, duty of good faith, is a safeguard against fraudulent performance. There are certain types of contract that court can impose a duty on the parties to perform the obligation under the contract. It is the agreement. It is beyond the basic of the agreement fruition and the operation of law. Okay, agreement means a contract can end. The parties agree not to perform the contract. What are the three types of agreements? Number one, a waiver to not proceed with the performance of a contract already in existence. Only effective if the waiver is given under seal. A new agreement is substituted for the original agreement, can occur by substantial agreement, accord, and satisfaction or novations. Number three, a contract may contain a clause that discharges the contract upon the occurrence of a condition precedent subsequent can contain an option to terminate. Agreement number two, Condition precedence, a clause that ends contract when a certain condition necessary for the contract to be performed is not met. Condition subsequent, what does it mean? It's an uncertain event which it is occurred and the contract. Frustration. What are frustration? Are foreseen as an event that makes a contract impossible to perform, or changes in the completely form where the parties intended. An impossible performance, operation of law, changes in the reason of contract. For example, during COVID-19, if you are a performer, you are a contract as a singer, during that period, there is an unforeseen outside event, such as COVID-19 epidemic. You cannot perform, so the contract will be void and valid, cannot be performed because of that unforeseen outside event. If you are performing sing or something like a band. Okay, frustration number 2. Frustration must relate to an event that occurs after the making the contract. Number 2, frustration event must make performance impossible, and the failure must not be self-induced. That's the key part. Must not be self-induced, self-inflicted. It has to be outside things, such as COVID. Good example. Frustration even discharges the party from further performance. It's called frustrated contract act. Allows recovery or expression from deposit or from person who received benefit from the frustrating event. Operation of law, a law passed by the government may step into the end a contract. Person filed for bankruptcy, they are released from many contractual obligations. The statute of limitation means limit the time you have to enforce a contract through the use of the court. Condition is an essential term of the contract. Okay. Warranty is a minor term of the contract. Any term less important than a condition is assumed to be a warranty. Breach of contract. A breach of contract occurs when one or the other the parties fail to live up to its obligation under the contract. This open up the party up to claim or damages to the other party. There are 3 ways that the breach may occur. What is that? Express repudiation, an action by a party that makes performance impossible, and failure to perform the term of the contract. What is express repudiation? Repudiation of a contract is when a party to a contract advise the other party before the date of the performance and they will not perform any of their contractual obligation. It can happen either verbally, in writing, or through a conduct. It happens before the contract is to be performed and is referred to the anticipatory breach. Okay, there are 2 types of repudiation. The first one is called express repudiation, a stated intention by a party not to perform any of their obligation under contract. Implied repudiation means intention by a party not to perform any other obligation under a contract that can presume by the action or lack thereof. Express repudiation, this is the process, okay, in terms of figure 7.1, is the process of express repudiation. Express repudiation, go to breach of conditions, injured party can contract as ended and sue for the damages. That's the key part. Okay. Rendering performance impossible. When a party does in something deliberately or through negligence that make performance of the contract obligation is impossible. Example, a contract to buy a lawnmower and the owner sell it to someone else before you can pick it up. Okay. It's almost impossible. Okay, a contract to buy a lawnmower and the owner sell it to someone else before you can pick it up. That's a good one. Rendering performance impossible. Action making performance impossible based on condition injured party can treat contract as ended and sue for damages. Okay, that's the key part. Failure to perform. A party to a contract fails to perform a term of contract that is vital and essential. If the party fails to perform the terms of the contract, then there is a breach of warranty. In this case, an innocent party must still perform their contract obligation but still can sue for a remedy. Example, failure to perform the term, there's a condition, the contract ends, sue for the damages. For warranty, there's also for damages. Okay, that's the key part. This is the flow. Failure to perform a term, there's a condition here, the contract ends for the damages. If it is warranty, go straight for the damages. Remedy for the breach of contract. A remedy is what the court can provide to the party who has been harmed by the breach of the contract. The most common remedy provided by the court is money. Limited liability in terms of a cost. This is in the event of the breach. Okay, the term in a contract that place a limit on the amount of damages that follow a breach of contract. Okay, let me just go back to 31. Limit the cost. Okay, that's good. We have covered this one. Second one is liquidated damages clause, a genuine negotiated estimate of the amount of damages that will follow a breach of contract. Exclusion clause is a term that removes liability and damages after certain specified breaches. A contract can also include indemnification clause if there has been a promise by either party to bear monetary costs for losses or damages incurred by another party. There are three legal remedies. Number one, an award for damages. Number two, an order to restrict performance. Number three, an injunctions. Award damages number one. A purpose for an award damage is to put the victim in the same economic position they would have been in if the contract has been completed. If damages is set at an amount punished to the party who breached the contract. Test of remoteness of damages number two. Award damage for number two. Did the damages arise naturally from the breach, or was it reasonable contemplation of the party as to properly resolve the breach? Were the foreseeable and probable consequences of the breach? Were any circumstances communicated or obvious to the party at the time the contract was formed? Expecting damages, a compensation for the loss of profit caused by a breach, calculated based on the profit a person anticipated earning from the contract. Land damage compensation for expenses incurred during one party relied upon the other party to perform their part of the contract or intended to put the injured party back in the pre-contract positions. Point number 4. There's a duty placed on the injured party as well as the breaching party. The injured party must take reasonable steps to minimize or reduce the cost of breach or contract term. Contract law typically does not compensate an injured party for initial losses in the breach of the contract. Remedy, equitable remedies for breach of contract. There are losses not only value. What are these? Rescissions, injunctions, specific performance, quantum merit, rectification, and accounting. What is rescissions? Rescission party are restored to their original position. This remedy is very common in retail environment. Example, returning a product that does not work to get your money back. This is the example of rescissions, okay? Rescission. Number two, injunction. It is a court order stopping a person from doing something that they are not supposed to do under a contract for inconsistent with the contract. A non-competition clause in an employment contract. You cannot work for another company in the same industry for a year. That's what we call injunction. Okay, this is very common being provided. Specific performance. Where minor compensation will not be adequate to repair damages caused by the breach of contract, a court may order a party to fulfill contractual obligations. Common for contracts for the sale of land and for contracts involving unique goods whose value is beyond money. Quantum merit, if a party completes part of a contract before repeating, they are entitled to be paid for the work they had done. They will also allow to have paid damages to the other parties for the cost of breaching the contract. Rectification. If it is a clear mistake, the court will grant an order amending the contract to ensure it will reflect the correct intentions of the parties. Accounting. A court may order license to product its financial record to ensure profit are distributed to the proper party. Enforcing the e-contract. In terms of jurisdiction and governing law, often the contract will state where the case will be heard, which law should be applied. This will normally be acceptable by court unless there is a balance of inconvenience, a balance of convenience, not inconvenience, balance of convenience argument that strongly favor another forum. Location is also taken into account. There are quick questions you need to know. They're related to this objective on this six objective. The first to the fifth. Okay, what are the 5 ways to contract can be discharges? Number 2, what does the frustration mean in the context of a contract? And what is the breach of contract? Number 5, what is repudiations? Okay. Continue key questions. What is liquidated damages clause? What is the equitable remedy? What is the balance of convenience? When is the remedy recognition appropriate? What is the purpose of remedy of quantum merit? What are the key terms? The key terms, this is key term number 1. Performance, the completion of a party obligation and a contract to the reasonable satisfaction of the other party. Breach means the failure of party to perform the obligation to the other party, reasonable satisfaction. Key terms number 2. Condition is an essential term of contract. Substantial performance means occur when all except for a trivial part of the contract obligation have been performed. Tender performance is an attempt by one party to a contract to perform its obligation under the contract. Indicates a willingness, readiness, and ability to complete the contract. Frustration. An unforeseen outside event that makes a contract impossible to perform or changes it completely from what parties intended. Warranty, it is a minor term of a contract. Damages mean a remedy that is in the form of the money. Express repudiation is stated intention by a party not to perform any of their obligation under contract. Implied repudiation, an intention by a party not to perform any of their obligation under contract that can be presumed by the action or lack thereof. Number 5. Limitation of liability clause, a term in a contract that prays a limit of the amount of damage that will allow a breach of contract. Liquidated damage clause is the union negotiate estimate the amount of damages that would follow a breach of the contract. Exclusion clause is a term that removes liability and damage after certain specific breaches. Okay, number 6. Indemnification, a promise by one party to bear the monetary costs for losses or damages incurred by another party. And test of remoteness of damage, the cause and effect of a party breach of contract that must have been something that could have been predicted at the time of the contract was formed. And this is the last term, expression of damages, is compensation damages for the loss. Expression damage is compensation for the loss of the profit caused by the breach, calculated based on the profit of person anticipated earning from the contract. Reliance damages in compensation for expenses incurred because one party relied upon the other party to perform their part of contract, intended to put the injured back to its pre-contract position. So this basically concludes this particular chapter. Thank you everyone. Bye-bye.